X hired Y as her driver for her daily commute to work. One Monday, X woke up an hour late. To get to work on time, she instructed Y to step on the pedal and drive fast. She also threatened to fire him if she got to work late or if he damaged her brand new car during the drive. Afraid to lose his job, Y beat a red light along Osmina Avenue. As a result, he hit a motorcycle, resulting in the death of the motorcycle driver. The bereaved family of the victim sued both X and Y for damages. X raised the defense that she was merely a passenger. As such, she could not be held liable for Y's negligence. Is X correct? Reasons. X is not correct. Under Philippine law, X can be held liable, solidarily with Y, for the death damages caused by Y's negligent driving. Under Article 2176 of the Civil Code of the Philippines, those who by act or omission cause damage to another, through fault or negligence, are obliged to pay for the damage done. Under Article 2180 of the Civil Code, employers shall be liable for the damages caused by their employees in the performance of their duties. Thus, if an employee, in the course of his employment or while performing tasks for his employer, commits a negligent or wrongful act, the employer may be held liable solidarily with the employee for damages. Under jurisprudence, the registered owner of a vehicle may also be held liable for damages caused by its operation, along with the driver and employer. Given the facts, X hired Y as driver. For her daily commute to work, there is an employer-employee relationship. On the occasion, X instructed Y to step on the pedal, to drive fast, threatened to fire him if X arrives late or if he damaged the brand new car. These are commands/directions from employer to employee in the course of performance of duties. Y, under instruction, beat a red light and caused death of third party. This act was committed in the performance of Y's work as driver for X. Thus, the negligent act is within scope of Y's employment. Being a passenger in the vehicle does not ipso facto relieve her from vicarious liability if she instructed the driver, hired him, had control over his performance, and the act was done in fulfilling her directives. The notion of mere passenger suggests lack of control or direction, but here X gave direct instructions, drive fast, threats, etc., which show control over manner of performance. Article 2180 does not require the employer to always physically be commanding at every moment, but that the act be in performance of the employment duties and under the authority or control, express or implied, of the employer. The giving of instruction to drive fast to arrive on time is consistent with employer's authority. Therefore, X is not correct. Under Philippine law, X can be held liable, solidarily with Y, for the death damages caused by Y's negligent driving.